Now I want to bring in my in-studio guest, criminal defense attorney Sara Becker is here. Sara, thank you for being with us. I want to ask you about the motion practice we've seen in the Weinstein case, in particular, the most recent motion. The defense wanting to have these jurors questioned behind closed doors so that it's done privately, so that perhaps they could receive more candid answers from these jurors without everyone hearing in open court. And the state responding today with that motion saying, no, 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 judge, this is not proper, it should be in open court and whatnot. The judge saying he's inclined to deny it. What do you think about the defense filing that motion, and which side do you fall in more agreement with in terms of legal arguments?
Julie, I tend to file that sort of motion when I'm litigating a case that has sensitive sexual issues. I think that it is just the way that you get more truthful and candid answers from jurors. You protect them from being influenced by what they hear from jurors around them. But more importantly, these are touchy subjects that you have to delve into in a sexually oriented case. You have to ask about personal experiences that might color their decisions. And my concern in these cases is always that you're not going to get a truthful answer from someone if they have to give it in front of a room full of other people.
Sure, especially talking about very sensitive things. If someone is a victim of a crime, perhaps it was a sex crime. And of course, we want to be protective of their privacy and their dignity and make sure they don't feel uncomfortable. I think any attorney, no matter which side you're on, would want that. I want to bring in another guest I have now. Criminal defense attorney and former prosecutor David Magruder is joining us live from New York City. And David, great to see you there. Thank you so much for being with us. And perhaps you were just hearing what I was asking attorney Sara Becker about these motions filed from each side, the defense wanting these prospective jurors to be questioned privately so that they can receive those answers perhaps in a more candid fashion, and the prosecution saying, no, this ought to be done in open court. You've practiced on both sides of the aisle. What do you say about this, please?
I think it's important to protect the jurors. You know, they're just called down here to do their service to society, and to make them relive some of these things is really tough. You have to be sensitive, especially in a case like this where people may find out what happened to them. They have to be asked about prior sexual assaults or things that may have happened to them. Very embarrassing, very personal. I think it's always better in this, particularly in a sexual case, to let them do it in private. Just recently, I've had jurors leave the room crying and re-traumatized just because they came down to do their jury service. As far as it goes for the two litigants, it has a minimal effect. What it can do, if people are aware that people are being excused, other jurors see that, and it makes them more. If you do it in public, the problem with that is the other jurors see that other people are being excused. So they start raising their hand and going up, and you know, it may encourage more people to come up to try to get excused. So I don't know that, you know, I don't know why they want to do it you know, I don't know if it's a good thing. And if the jurors get any indication, although they shouldn't, that one side or the other is making them do this in public, then it could have an effect. Potentially, it doesn't often happen, but it could have a potential effect on, you know, which side they're favoring or not. So I would, for sexual stuff, I would err on the side of letting it go private. I don't think it's going to have, whether it's private or public, as long as you get the information out to the court and on the record, I don't think it's going to have that big an impact at the end of the day. But I think the information should come out, to be fair, especially to the defense.
I appreciate your thoughts on that, David. What about splitting the baby, so to speak, where the questioning's done in open court, but if we know we're going to go down a line of questioning in which someone is a sex assault victim, sex assault survivor,
yes,
if there needs to be more questioning done to determine whether each side thinks this person could fairly and impartially hear the case, perhaps they could then move into the judge's chambers or into a private area where they would be removed from the earshot of other potential jurors. What do you think about that as a potential possibility here?
That's probably, I think you hit the nail on the head. That's probably best practice, and that's what a lot of judges that I'm before. I'm here at 100 Center Street most days. That's what a lot of judges in that building will do. They'll kind of, you know, feel it out. The judge has a lot of discretion in jury selection, a lot of discretion. And the appellate courts have left, they don't really touch that as much as people may think. I think that's a good way to split the baby, but keep in mind, we go back in the chambers with people who have been traumatized. they're still being re-traumatized. They're still saying it in front of at least 3 strangers, would be the judge, the defense, and the DA. And so just keep that in mind. They're still re-traumatized, although that bit of pain may have to be endured to make sure that both sides are getting a fair trial.
That's a great point, especially coming from a former prosecutor, also currently criminal defense attorney David Magruder. Thank you so much. You're going to stay with us throughout the show. We appreciate that. Sarah, I want to turn back to you. Sarah Becker, criminal defense attorney in studio here. What do you think about that suggestion and David Magruder saying that's something that is done in that jurisdiction where he practices? Maybe split the baby. What do you think? Do you think that'd be fair to both sides?
It's something I've certainly had happen in cases that I've tried as well. I think the issue with it is that you're still requiring that person to disclose that they have been a victim or they've had an experience, that you know that identification of you as someone who has to be separated out is still something that may kind of stop people from acknowledging that that's happened. I think we also have to consider the other side of the possible equation as well, where we may not just be talking about victims of sexual assaults. It's possible that the people on the jury have been accused, either rightfully or wrongfully, of a sexual assault in the past as well. And I think that especially is something that they may not want to be even singled out for.
That's a great point to end the segment on there. Sarah Becker, you're going to stay with us. We thank you for that. When we come back, we'll be talking about a missing Connecticut mother. The main suspect in this woman's disappearance is out on bond, posted a $6 million bond at that. That is coming up for you on Court TV Live. Also, I want to remind you that we've got a brand new episode of the Court TV podcast happening right now. My friends Vinny and Seema are talking the Weinstein case, particularly about what took so long for charges to be filed against the famous Hollywood producer.
Can you believe that we're here?
I cannot believe that we're here. I cannot believe that it's finally happened, that we are on the precipice of one of the biggest trials this country has ever seen in decades, and we'll be covering it gavel to gavel.
Absolutely. And the reason it's so big is because of obviously who Harvey Weinstein is, but what it represents and how it has changed our culture here in the United States. But let's figure this whole thing out.
Yeah.
Where do we start? Where did this whole thing start?
So this started, there's so many accusers as we sit here now, there's close to 90 accusers, but it started with just one, and it started back in March of 2015.
And you can find the latest podcast episode on Stitcher, Apple, and Google Podcasts. And of course, we've got it for you on your favorite website, courttv.com. We're back right after this. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. We're so grateful for your company on this Tuesday as we cover 2 big trials for you. First up, jury selection is set to get underway in the state of Florida versus defendant Donald Hartung at 2 p.m. Eastern Time. The facts are just heinous. This guy is charged with 3 counts of first-degree murder for the 2015 deaths of his mother, Von Seal Smith, and his half-brothers, John and Richard Smith. The 3 victims, there they are there, were found in their mother's home with stab wounds to their neck. All 3 of them had stab wounds to their neck. They were also beaten with a hammer, and one of them was shot in the air. Now, this is a death penalty case, and we could hear those opening statements happen as soon as tomorrow. We're watching the jury selection unfold. This is in Pensacola, Florida, this case. And there are also some allegations that witchcraft could have been potential motivation by the defendant. We'll see what the prosecution says in their opens. But again, this is going to happen possibly tomorrow in terms of opening statements, jury selection happening this afternoon. And in New York City, we are in week number 2 of jury selection in Harvey Weinstein's rape trial. There he is, getting ready to enter the courtroom this morning. Another pool of potential jurors in court answering more questions. A fresh pool brought in today. The disgraced Hollywood mogul charged with multiple sex crimes against 2 different women. And the supporting witness in this case, who's not a complaining witness, is Annabella Sciorra, famous actress, also going to be involved in this case. And, since those allegations of sexual assault against Weinstein came to light back in the year 2017, more than 80 different women have come forward to accuse Weinstein of misconduct. Court TV legal correspondent Chanley Painter takes a look at the timeline in the Weinstein case.
October 5th, 2017, a bombshell. The New York Times reveals details of Harvey Weinstein's alleged decades-long history of sexual misconduct and harassment. Actress Ashley Judd is among the accusers. 2 days later, Weinstein is fired from the company he co-founded. His employment with the Weinstein Company is terminated effective immediately, says a statement released by the company's board. October 10th, 2017, a new report from Ronan Farrow in The New Yorker. 13 women accuse Weinstein of harassment and sexual assault. Celebrities Rosanna Arquette and Mira Sorvino claim their careers suffered after they rejected Weinstein's advances. In the same article, Italian model Ambra Battilana Gutierrez accuses Weinstein of groping her. She confronts him in this secret recording she made for police.
Please, I don't want to do something I don't want to.
Go to the bathroom. Come here. Listen to me.
I want to go downstairs.
I'm not going to do anything. You'll never see me again after this. Why can't you come
Yesterday
back?
you touched my breast.
Oh, please, I'm sorry. Just come on. I'm used to that. Come on.
Are you used to that?
Yes, come in.
No, but I'm not used to that.
I won't do it again. Come on.
Harvey Weinstein's wife of 10 years, Georgina Chapman, announces she is leaving him. She says, "My heart breaks for all the women who have suffered tremendous pain because of these unforgivable actions." October 14th, 2017, the Academy of Motion Picture Arts and Sciences expels Weinstein. His films have earned more than 300 nominations and won 81 Oscars. The next day, actress Alyssa Milano invites those who have been sexually harassed or assaulted to reply with #MeToo. The tweet goes viral, launching the Me Too and Time's Up campaigns around the world. By December of 2017, the Weinstein scandal grows. More accusers, more lawsuits, and criminal investigations underway in Los Angeles, New York, and London. March 2018, it is Hollywood's biggest night. Weinstein accusers Ashley Judd, Annabella Shora, and Salma Hayek take the stage at the Academy Awards and speak out.
This year, many spoke their truth, and the journey ahead is long, but slowly a new path has emerged.
Later in the month, the Weinstein Company files for bankruptcy. Dozens of women have come forward accusing Weinstein of sex abuse or misconduct. May 25, 2018, Harvey Weinstein surrenders to a Manhattan court. He is accused of rape and related criminal charges and incidents involving 2 women, dating back to 2006 and 2013. August 15, 2019, a new criminal indictment is filed. This one paves the way for actress Annabella Shora to testify against Weinstein. She claims he raped her in 1993. Weinstein denies any criminal wrongdoing, and his attorneys say he will prevail.
We have evidence that makes us believe they cannot prove these were non-consensual encounters.
Weinstein's once rich legacy as Hollywood's ace producer,
I feel that we've done a lot of, great things.
is now diminished.
I am happy to leave, but nobody's gonna say anything. I'm gonna stand 4 feet from a rapist.
All right, turning to the day's other legal news now. The investigation into the disappearance of Jennifer Dulos continues this afternoon. Have you heard about this case? The Connecticut mother of 5 has not been seen since last May. Now, the #1 suspect in the case is walking free on bond. Our affiliate, WPIX-TV in New York City, brings us the latest.
How are you holding up? Facing felony murder charges and the rest of his life in prison, Fotis Dulos is free for now.
Do you think the murder charges will be able to stick?
Pix 11 was there as Dulos posted a $6 million bond. A black SUV was waiting to whisk him away. Also today, Dulos' attorney Norm Pattis sat down for an exclusive interview with Pix 11's Anthony DiLorenzo.
To post a $6 million bond, Mr. Dulos would have to come up with a cash fee payment to the bondsman of $420,000.
Dulos can now wait for trial in his Farmington, Connecticut mansion instead of jail, but he will remain there on house arrest.
The bond conditions will require that he wear 2 monitors, a GPS monitor and then another electronic monitoring device.
Prosecutors believe last May, Dulos murdered murdered his estranged wife, the mother of his 5 children, Jennifer Farber-Dulos, but her body has not been recovered. Defense attorney Pattis opened up today about a strategy he might use in front of a jury.
I've probably gone too far already.
Explaining a theory of third-party culpability.
A lawyer's way of saying what is said on the street. Some other dude did it. Under Connecticut law, you can place third-party culpability before a jury if there's some reason to believe that someone else may have been involved.
Also arrested this week, Dulos' friend and civil attorney Kent Mawhinney. He's charged with conspiracy to commit murder for allegedly digging a makeshift grave. He is not expected to post his $2 million bond. Dulos' ex-girlfriend Michelle Troconis was also charged with conspiracy to commit murder this week. Troconis was taken to Stanford Hospital for an evaluation this afternoon after posting her $1.5 million bond.
All right, I want to bring in our guest in the studio, criminal defense attorney Sara Becker. So Sara, let's talk a little bit about this case. Awful allegations being brought against the victim's husband. Her body still hasn't been found. My question to you is, when you're trying a homicide case and you're on the defense side, as you are in criminal practice, does that make the case any easier for you? Does it increase the chances any more so if there was a body found and recovered and that evidence to be introduced by the state?
Julie, it really depends on how strong the other circumstantial evidence of death is. So, they find a bloody room and fragments of the victim's skull and DNA evidence of them, then you're going to have a hard time pursuing it didn't happen. There's no body. You can't prove that someone's dead defense. But certainly what it does is it leaves you more options open, because you don't know what the whole story is. And as a defense attorney, my goal is always to come in with a story, a theory of the case, right?
Yes.
Not just reasonable doubt or they can't prove it. You want to come in and say, my client is innocent, and here's the story that you can relate to that tells you why.
Yes, you've got it. That's the way to do it. That is. What do you think with the defense team here? And I know the details are still very, very limited. We're only seeing a little bit of information about this case, but it sounded in that report there, at least, that they may be pointing to, some other individual was responsible. Do you think if there is no body recovered, for this beautiful victim, mother of 5, that maybe that's the most viable defense?
Possibly, given what I think we know about the evidence so far. I believe there's some evidence that there's surveillance video that may link him to disposing items that were found to have the victim's blood on it. Right. So then again, that might be the circumstantial evidence that makes it hard for you to argue that no crime occurred. But perhaps it makes it easier to argue that you weren't the one who did it.
Sure. This is certainly a case to watch. He was able to post that bail today with the help of a bail bondsman. I believe the amount was about $425,000 cash. He provided the bondsman in order for the bondsman to put up that $6 million he was charged on. Wonder why he wasn't being held with no bail. That's a question there. We'll see what happens while he's out. Sara Becker, thank you for your expertise. We're going to take a break now. When we come back, my colleagues will be here sharing their expertise. Your daily sidebar happening right after this break. We're talking about this brand new trial we're covering for you here on Court TV. And is it intriguing as ever with the allegations being levied against Donald Hartung? He's accused of killing 3 of his own family members, and witchcraft was potentially the motivation for the crime, according to some of what we've dug up and what investigators have written in their affidavits. Stay with us. We are back with more Court TV Live in your sidebar after this.